All right. Good evening, everyone. It's wonderful to see all of you here. Welcome to our special webinar on asset protection and estate planning. We truly appreciate you taking the time to join us tonight. Your interest means a lot to us, and we are thrilled to have you here. I am Anchal Dwivedi, managing partner at Goldstone Capital Ventures. I am joined by my fellow managing partner, Dinesh Nayak, and Shruti is not able to join today. But we have a special guest, Lars Kissling, owner at Oak City Estate Planning. At Goldstone Capital Ventures, we are passionate about identifying, underwriting, acquiring, and managing commercial properties with significant value add potential. Our mission is to transform these properties into vibrant communities, providing financial benefits to our investors and creating appealing living spaces for residents. We are dedicated to delivering exceptional real estate investment opportunities, ensuring our clients' success through strategic asset management and innovative solutions. Please feel free to capture this slide and schedule a call with us to discuss how you can partner with us in future investment ventures. In addition to value-add investments, we also have brand new apartments and other commercial properties. So we have acquired over 16 real estate assets, totaling more than 1,600 units in key locations across Carolinas, Texas, Tennessee, Wisconsin, Florida, and beyond. Our diverse portfolio includes value-add apartments, ground-up constructions project, student housing, assisted living facilities, short-term rentals, and more. We are also excited to expand into Virginia and explore new markets for industrial and flex spaces to meet the growing demand. We are actively seeking medical building nationwide to further enhance our portfolio. Our upcoming projects in various asset classes highlight our commitment to diversification and delivering outstanding result to our investors. Our team's expertise in market analysis and underwriting ensures that every investment is positioned for optimal performance. Now, I'll hand it over to Dinesh, who will walk you through our current portfolio and recent acquisition, and also introduce our guest speaker. Thank you, and let's get started.
Hey, thanks, Anchal. Good evening, everyone. My name is Dinesh Nayak. I live in Richmond, Virginia. This is a general disclaimer. We are not giving any advice from financial, accounting, or investment perspective. So this is totally from education perspective. So our goal is to educate our audience in various subject matters. So today we have a very critical, most important topic, which is asset protection and estate planning. So here I would like to give some real highlights of our portfolio. This is a assisted living property, 125 beds that we purchased last year in Wisconsin, and it is doing amazingly well. It is 98% occupied at this point. East Main Quarters, this is a student housing facility, 252 beds in Nashville, MSA, just outside Nashville in Murfreesboro. Middle Tennessee State University, just 0.1 mile from the campus, very walkable. Ivywood Apartments, this is in South Carolina, 96 units, 1997 built. This is a new construction project that we have started, 184 units in Winston-Salem, North Carolina. Sweet Redemption, this is a very beautiful property in Arlington, Texas, just outside the Cowboy Stadium, and we have converted this into short-term rental units, and it is the value has actually almost doubled in the last 1.5 years. Chesterton Place, this is another 98 townhomes, 49 duplexes that we bought 2022 December in Spartanburg, South Carolina. Another Class B property in Charleston area, and there are a few other smaller properties that we haven't really displayed here. With that, I would like to introduce our guest speaker. Before that, a couple bookkeeping, housekeeping items. One is you can take take a picture of this QR code where it takes you to our cash flow portal, and also you can set up a call with us here. The other thing is there is a Q&A box. You can enter your questions using the Q&A box. And again, thanks lots for accepting our invitation. We are really thankful for coming here and spending time with us. And Lars, he has more than 30 years of experience in all these subjects like trust, wills, estate planning, the elder laws, Medicaid, probate. All these are very, very important areas. He's going to explain all this. And uh, he's an attorney and a founder of Oak City Estate Planning. And yeah, Lars, please take it from here. Stage is yours.
Thank you very much. Just a little bit about me. I'm the youngest of 7 children. I grew up in a big family. Out in Los Angeles, I practiced law in California, New York, Connecticut, Massachusetts, and North Carolina. Everything I talk about this evening, it's general information, but most of it's going to be geared towards North Carolina law. So any specific things, if you're in a different state, may vary from state to state, but these will be kind of general information. The first thing I like to talk about in general is what is estate planning? What does it consist of? Everybody should have an estate plan, no matter how much or how little you have. There are certain things like power of attorneys and healthcare directives that anyone over the age of 18 should have that. I've got a 21-year-old, I've got a 17-and-a-half-year-old. My 21-year-old has a power of attorney and a healthcare directive. If he were to go to the hospital, the doctors couldn't talk to me because he's over 18, even though I'm his parent. And so everybody over the age of 18 should have power of attorney and healthcare directive. He's in college. He doesn't have any stuff. He doesn't own anything. So he doesn't need a will. He doesn't have to worry about distributing assets at this point in time. But as he does, he'll grow into those things. The other thing you should think about when you're thinking about estate planning is not something you do once and you forget about it. It's something that's going to change as your life progresses. When you're single, you're going to have one type of plan. As you get married, before you have children, when you're just starting to acquire your assets, you may have a different type of plan. When you're older, you're getting close to retirement, you've accumulated a good amount of assets, you should have a different type of plan there. So don't think of estate planning as something you're going to do once and then you're done, but it's going to progress and keep it, and you want to keep it up as your life changes. Less than 4% of the plans people create in this country work the way they're intended to. And the biggest reason they don't is they don't keep them updated. Their life changes, the people in their lives change. And so what they thought was going to happen in the end doesn't happen because they haven't kept it up over their lifetime. So you really want to make sure you keep it up. One of the things we offer at Oak City Estate Planning is a maintenance plan, which is an annual fee you pay to us, which not only gives you access to us, but it helps us to make sure your plan is kept up to date every year. The law changes, your life changes. We're going to help you keep it up to date. So your basic documents when you're putting together an estate plan is going to be your will, your power of attorney, your healthcare directive. We talked about the healthcare directive and we talked about the power of attorney. But what is the will? What does it do? Well, the will distributes your assets when you die. Now, if you don't have a will, the government still has a plan for you, and that's called intestacy. If you die without a will, the government has an order of distribution that's going to determine how your assets get distributed. Now, if you're married and you die without a will, any assets you have that are solely owned by you are not necessarily going to go to your spouse. In North Carolina, those assets would be divided either equally between your spouse and your children if you have 2 or fewer children. But if you have more than 2 children, your spouse is only going to get 1/3 of the assets. And I've been married almost 29 years and I can't think of anybody who's been married for any period of time who would not want their spouse to inherit or take all of their assets that they'd want it to go to their children before it went to their spouse. Now, a lot of people think that if you have a will, you're going to avoid probate. And we'll talk about what probate is in a second here. But if all you have is a will, you are guaranteed probate. Wills do not avoid probate, they guarantee probate. So what is probate? Probate is the legal process of transferring ownership from the person who passes to whoever they leave it to. Any assets that are solely owned by you, that are not jointly owned with someone else or do not have a payable on death beneficiary, have to go through the probate process in order to transfer ownership. That costs money and it takes time. I will typically charge, and the industry is probably this, 2% of your assets to go through the probate process. So if you've got, for every $1 million worth of assets you have, you're going to pay an attorney $20,000 to get you through that process. And that's why most people want to avoid the process. The common misconception, though, is, well, if I have a will, I'll avoid probate. That's not true. One of the ways to avoid probate is with a trust. Now, I'm going to share my screen here with you.
Yeah, you can share it if you want.
Second here.
Yeah. Now you want to
There we go.
slideshow?
Yeah, I just couldn't get something out of the way there.
Yeah. You can click on the first one, I think.
See, this shows you that I'm not a tech guy.
Yeah, you can click slideshow and click the first button. Yeah, click the slideshow menu.
I know the problem is that yeah.
You can click on the, okay, yeah, play that. Oh, no, you can do enable editing. Just click on the enable editing on
Yeah.
the,
Here's the problem.
yeah, right. Okay, yeah, now you can do that.
There we go. Sorry about that. So this is just the name of my firm. So we talk about trust. The first divider when we talk about trust is testamentary trust and living trust. When we talk about living trust, we have revocable and irrevocable trust. Testamentary trust is a trust that's created through your last will and testament. It does not exist until you die. It doesn't avoid probate. You can't put anything into it during your lifetime. Your typical testamentary trusts are either what we call understated age trusts. My children don't get the assets outright until they reach the age of fill in the blank. It used to be people would do 18, 25, 35, different amounts at different times. That's not very typical anymore. The other typical testamentary trust is if you have special needs beneficiaries, so that you can put their assets into a trust and they won't lose their government benefits because they've inherited from you. If this is what they're getting government benefits up to here, you want to give them the extra. And by putting it into a special needs trust, you don't lose the government benefits that they're receiving. So that's the testamentary trust. It provides a little bit of protection for your children until they reach a certain age, but it does not avoid probate. It typically is not used by anyone who has any real assets that they want to pass on. So when we get into the living trust, we have revocable and irrevocable. Think of a revocable living trust as an open box with a lid. During your lifetime, you can put anything in, take anything out anytime you want to. It's very flexible. One of the benefits of any type of living trust is it avoids probate. When you put something into a trust, you no longer own it. The trust owns it. Just like if you put it into an LLC or a corporation, those assets are no longer owned by you. They're owned by the separate entity. And while you don't own the assets that are in the trust, the person who creates the trust is called the grantor. During the grantor's lifetime, they are the trustees, so they control what's in that box. A lot of people have issues with giving up ownership of their assets. But what you really want is control of your assets. How they're titled, who actually owns them, has very little effect on you. It's who has control of those assets. And as long as you are the trustee of the trust, you have complete control of the assets. Again, it's very flexible. You can put things in, take things out anytime you want to. One of the main benefits, it avoids probate. As I said earlier, the only things that go through probate are the things that you own when you die. If you put something into a trust, you no longer own it, so it does not have to go through probate. So the biggest advantage of the revocable living trust is that it avoids probate. The other advantage of a revocable living trust is, I said it was that open box with a lid. When you die, that lid closes and it becomes irrevocable for your children. Now, one of the drawbacks of the irrevocable trust, because it's that open box, is it doesn't protect your assets from your creditors and predators during your lifetime. So if you were to go into a nursing home and try to get on Medicaid, or if you were to get in a car accident and get sued, or if you had a business venture that went bad and people were suing you, they could get to the assets that are in that box because it's open. If you can get to the assets, your creditors and predators can get to the assets. But when that lid closes, when you die, your beneficiaries, which would typically be your children, but they can be anyone, their creditors and predators cannot get to those assets during their lifetime as long as they keep them in the trust. For example, you put money into the revocable trust, you've passed and the lid closes. Example, we'll use my kids as an example. So the money, my wife and I passed, the money's in that now closed box. And my son is now 25, he's going to get married. He would go to the trustee and say, hey, my parents left me this money, it's in this box. I need to get some money out so I can buy a house so that my new wife and I can live in it. And my trustee, who I trust, who's a very intelligent man, is going to say, great, but I'm not going to give you the money for the trust or the money for the house. We're going to have the trust buy the house. So we're leaving that equity, that property inside the box. But now instead of it being cash, it's a house. And my son and his wife get to live there, raise their family there. But say my daughter-in-law now decides to run off with the pool boy. And she's thinking, well, we have this house. I get to take half of it when I leave the marriage. Well, she doesn't because my son doesn't own that house. The trust owns the house. So I've given my son the benefit of what I've worked hard for, but it's in that box and it's protected. So his creditors and predators cannot get to it. That's a big advantage of passing on your assets through the revocable trust. So open during your lifetime, your predators and creditors can get to it. Closed after you die, so your beneficiaries, creditors and predators cannot get to it. That's the revocable living trust. Irrevocable living trust, closed box. Once you put something into it, you cannot take it back. So again, it avoids probate because you don't own it. But you can't put, say you can't put a piece of real estate in there and then sell it and take that and take the money back. Once you put it in there, you have to keep it in there. But what you can do is, say, for example, you bought a two-family house, a duplex that you're using as rental property. And then one day you decide, hey, I think I can make more money if I sell the 2-unit and buy a 4-unit. You can, as the trustee of that trust, sell the 2-unit and then take that equity and use that to buy the 4-unit. But the 4-unit has to be kept in the name of the irrevocable trust. You cannot take it back and put it back in your name. Likewise, you can go the reverse way. If you put your house, say your house is worth $1 million, and you put it into an irrevocable trust. And then as you age, you decide, hey, we don't need this big house. Our kids are grown. Time to move into something smaller. You can, as the trustee of that irrevocable trust, sell your house. Say you sell it for $1 million and your new townhouse is going to cost you $500,000. You have to keep the new townhouse in the trust, and then you've got $500,000 worth of cash. You need to keep that in the trust, but you could put that in an investment account, or you could buy rental property, do whatever it is, but it still has to be owned by the trust. You can't put it back in your name or take it back. Because you can't take things back, you don't want to put things into a trust that you think you may need during your lifetime. And lots of different factors go into that. Your age, where you are in life, what other assets you have available to you. But if you have assets that you don't anticipate you're going to need during your lifetime, the best way to protect them is through an irrevocable trust, because it immediately protects that. Once you put it into the trust, it immediately protects it from all your creditors and predators. There is one exception, and that's Medicaid. So when you put something into a trust, the trust doesn't give you anything back in return. If you take your $500,000 house and put it in the trust is not giving you $500,000 back in cash. That's called an uncompensated transfer. Medicaid has a 5-year look-back period for uncompensated transfer. That means that if you transfer property into a trust, there's going to be a penalty for you for that transfer if you try to apply for Medicaid or go on Medicaid for that first 5 years. But once you get past the first 5 years, it's completely protected from everybody. Medicaid can't touch it. Your creditors and predators cannot touch it. So those are basically the 3 different types of trusts we use. The big difference between the revocable and the irrevocable is the revocable living trust does not protect the assets from your creditors and predators during your lifetime. The irrevocable does. Do we want to stop and take questions here about trust?
Yeah, sure. If anyone has a question about trust, please put it in QA and we'll address them now.
Yeah, lots. Why would someone create a revocable trust instead of irrevocable? I was not clear.
I'm sorry, say that again.
So why would somebody create revocable instead of irrevocable trust? I see irrevocable is more beneficial.
People would use a revocable in a time frame where they don't have the type of assets, or they're not really old enough where they can say, I know I'm never going to need that asset during my lifetime. So with your potential clients who are investing, they probably have the type of assets that they're investing, they're not living off of that money. That's for generational growth. They could probably do that. But if you are, say, a person in your 40s, you don't have a lot of investable assets, but you have your home, you have your 401k, different savings accounts, things like that. That's where a revocable trust is going to be beneficial, because it allows you to avoid probate, but it's still going to allow you to get to those assets during your lifetime. Again, the only things you would want to put into an irrevocable trust are those assets that you know you're not going to need to touch because you can't take them back.
Right. Okay.
One of the other advantages of a living trust is you can name one way to avoid probate is to say, with a retirement account or with a savings account or some type of investment account, you can name other people as payable on death beneficiaries so that the assets transfer automatically to those people outside of probate upon your death. That's a way to avoid probate. The problem with doing it that way, number one, it doesn't provide any protection. So if you had children under the age of 18 and you have them named as the payable on death beneficiary of your accounts, well, they're automatically going to get that at 18. You don't get to put any type of age restrictions or any other type of restrictions. But if you name a trust as the beneficiary on death of those accounts, think of the trust as a rule book. You can put any rules into it you want as to how your beneficiaries have access to those assets. So your if you have the trust as the beneficiary versus individual people, you get to put a whole set of rules together as to how and when they get the access to those assets to help protect it for them.
Okay, got it. Yeah, I think we can move on and probably address questions at the end if there are any.
Okay. One of the other things you asked me to talk about was business structures. I don't do a lot of that. My familiarity with those is partnerships versus LLCs versus corporations. Most people, and I'm not sure if you have people setting up LLCs for their investment properties. I know that's a common practice. Most people do that to separate liability from assets. So you might have, if you have a rental property, you might want to put that in an LLC. So if there was some liability that came from, say, a slip and fall or something like that with a rental property, if it's in the LLC, the assets in the LLC are the only assets that someone suing you would have available to them. They couldn't go after your personal assets. So that's one of the reasons people do that. What most people don't think about is the reverse of that, of what if you get into an accident in your personal car and somebody sues you, can they go after the assets of the business, of the LLC? Well, they can't go after the assets of the LLC. So if your LLC has a piece of a rental property in it, they can't go after the rental property. But what they can sue you for is your ownership in that LLC. So any profits you would be getting as a member of the LLC, they can attach that from your personal liability. That's where an irrevocable trust, if you put your ownership of the LLC into, or your stock in a corporation, if you put that into an irrevocable trust, and then you got in a car accident, they couldn't even go after your ownership of that business because that's protected in the irrevocable trust. That's about the extent of my knowledge on business. Did you have a question?
No, that's fine. Yeah,
that's
good.
All right. One of the other subjects you asked me to talk about was insurance strategies. In general, you should have as much, and I don't sell insurance, but I advise people on it. In general, you should have as much insurance as you have assets to lose. I think umbrella policies are relatively cheap. So if you got if you got $5 million worth of assets that you can lose, you should have $5 billion worth of umbrella policy. They're cheap and it helps to protect your assets that way. One of the things we do talk a lot about is long-term care insurance. Here in Raleigh, the average nursing home is going to cost you between $12,000 and $15,000 a month for skilled nursing care. Long-term care insurance is expensive. The policies are getting better. The old policies were more like car insurance policies where you paid high premiums, but if you never went into a nursing home, you never got any benefit from it. The newer policies are life insurance policies with a rider that covers long-term care. So if you never end up using the long-term care part of it, your beneficiaries will get a life insurance payout at the end. The other thing I see people doing is if nursing home is going to cost you $14,000 a month, people are not buying insurance to cover the entire 14. They might buy insurance to cover half of it, $7,000 a month, just to reduce the amount of exposure they're going to have. And so they won't eat up all their assets by paying for long-term care. When it comes to nursing home care, the average person's in long-term care, in nursing home care for 3.5 months, which, you're looking at $45,000, $50,000, which a lot of people can manage that. The problem is that's the average. My experience with my family, my mother had Alzheimer's. She was in a nursing home for 3.5 years. My dad was very healthy up until the end. He was only in a nursing home for 2 weeks. The problem is you don't know which one of those you're going to be. So it's hard to plan. And that's why long-term care insurance is a good thing to look into. Do you guys sell long-term insurance? Okay.
Yeah.
There's kind of a sweet spot for long-term care insurance between, you don't want to pay it for too long, but if you wait too long, you won't be healthy enough to get it. So typically between 55 and 65 is when people should start looking at long-term care insurance to see if it's a viable option for them for paying for long-term care. Retirement accounts and exempt assets. Retirement accounts, we don't typically put into trust. We name the trust as the beneficiary, so that it will go into the trust, and you can put some rules on that. You still have to comply with the federal government's rules on that. But those assets are already protected from your creditors and predators, so you don't have to worry about anyone getting access to those in the case of an accident or something like that. And then almost all of my clients put their personal residence into some type of trust, whether it's revocable or irrevocable. Again, because they can sell it and buy new ones. And it's not really that difficult to do it. It's a way of passing on that wealth and protecting it and avoiding probate. Even residences that have a mortgage on them, we put into a trust. Mortgage companies don't really care who owns the property, because transferring it into the trust doesn't extinguish their lien. And so as long as they're getting paid, they don't tend to care.
Yeah.
Anything else you guys wanted me to touch on?
So you can put a property under LLC, and LLC can belong to a trust, right?
Correct.
So, okay.
Does a living trust help with taxes in any way?
No. So the living trust uses your social security number for your tax ID number. So any gains, even if the property is in the trust, any gains are going to be taxed at whatever your personal rate is, which is actually better than if it was taxed at the trust rate, because the trust rate's typically higher than your personal rate. It's not until you pass that your trust would have to get its own tax ID number, and then it would be taxed at the trust rate, but you still get the step up in basis that you would if it wasn't in a trust. So if you have real property in the trust and then you pass, your beneficiaries are still going to get that step up in basis.
Okay.
Okay. Yeah, again, if you have any questions, please enter them in Q&A box. So this umbrella insurance, for example, if we have a property, rental property, and we will have insurance on that, the what should be the amount of coverage on general liability? Will it be like the market value of that particular property, or
Yes, because that's what you have to lose. If the LLC gets sued, whatever the assets are in the LLC, you should have enough insurance to cover that. But $1 million worth of umbrella policy coverage. So to get an umbrella policy, you have to have whatever the insurance company's maximum limit is for property insurance. Yeah. I just happen to have my insurance statement right here. Let me see if it has the information in there. Yeah, it doesn't have it on here. So I've got $1 million insurance policy. I'll bet I pay less than $50 a month for that policy. It's really cheap. Because your umbrella policy is not going to kick in until all your other insurance has been exhausted. So like I know for my auto, which is everybody's auto insurance tends to be their most expensive because that's where your greatest amount of liability is when you get out in your car. I'm required to have a 250-500 policy, which is $250,000 per person, $500,000 per incident, which is the maximum most insurance companies write for auto. They're going to make you have that, which is going to be the most expensive part. And 99% of your car accidents are going to have less than $500,000 liability, even if somebody gets killed. So the chances that your umbrella policy are going to kick in are so slim that's why they're so cheap, that they usually don't pay out.
Okay. And can you explain what exactly happens during the probate process?
Sure. So if you pass, anything that you have that's jointly owned is going to pass to whoever's name's on there. So if you're married and your accounts are jointly owned with your spouse, those don't go through probate because they automatically transfer. But things that have titles, so say a car, in order to if that's just in the name of the person that passes, the title's got to be transferred. And your spouse or a friend can't just walk into the DMV and say, hey, this person's died. Here's their death certificate. I want to transfer title. It has to go through the probate process, meaning you have to make an application to the court, and the court then issues what's called letters of testamentary. It's just a document which now gives the executor, the person named in the will who's supposed to distribute the assets, the legal authority to start doing that, to gather the assets, to pay the bills, any debts, and then transfer the assets to whoever the beneficiaries are. So you have to report all the assets to the court. You have to do several accountings throughout the process. And then you have to show the court does a final accounting to show that you gathered all the assets and then distributed them all. And that's just a process. It typically takes about a year. So if you've got people who depend on those assets, you don't want them to have to wait that long or pay the fees. There's not only attorney's fees, but there's court fees You don't want them to have to pay all that and go through the process before they get those assets that you want them to have get passed on to them.
Thank you. All right. I know you cover special needs planning as well.
Yes.
Is that similar to, the assisted senior living?
Yeah.
It's-
Special needs planning is for beneficiaries who have special needs, who qualify for special needs benefits from the government. So if you have a beneficiary who's maybe been injured or maybe has autism or something like that, and they're getting government benefits, special needs provision in a trust or a will puts that money in a sense in a separate box for them, so it doesn't count against them to do. The government benefits they're getting is based upon what assets they have available to them. So the assets in that special needs trust, that box, don't count against them towards qualifying for those government benefits. Because most people, when you leave something to someone who's on government benefits, you don't want them to lose the government benefits. You want them to get extra. Those are the types of things you want for them. And that's what that does.
Okay. I know you have practiced over decades, multiple decades. Do you have any, the story that you can talk about that you have come across during your practice?
Sure. In general, I always tell people you can always trust people until you can't trust them. So you can say, oh, I can leave this to someone, they'll take care of my children, they'll do whatever. Well, hopefully they will. But what if they don't? And you can't wait till it's too late. All right. We live in a society where people get divorced. We all know situations where people have gone through tragedy, they've lost a spouse, something like that, where they've suddenly started making bad decisions, right? So you want to protect them from themselves. I have a client, grew up on 700 acres in Wyoming, generational property, had been in the family for 100 years. His mom passed when he was younger. He and his brother and his dad were living on the property. His dad got remarried. His dad trusted his new wife. She'll do the right thing by my boys. Leaves everything to his new wife. Well, she then left everything to her children from her first marriage. So you have these two boys that grew up on this generational property. It was suddenly out of their family because their father had not put protections into his estate plan to make sure that that property got passed on to his children. And if he wanted his new wife to live on that property until she passed and take care of her, he could have done all of those things without putting that property at risk for his boys, but he didn't do any of those things, right? So again, he trusted someone, and I'm not saying he shouldn't have. I don't know all the facts, but she didn't do right by his boys. And those are the types of things we want to protect someone from letting that happen to their family.
Okay.
I also, this is just recently, I had a couple come in, her mom had died, and she had prepared her own will, gone to LegalZoom, done it online. She wanted to save some money by not having it done by a professional. Well, she didn't fill out the form right and ended up leaving all her assets to John Doe. So she didn't have a will because it wasn't a legal will. You can't leave your assets to John Doe. John Doe doesn't exist. So people I can understand and I respect people not wanting to waste money. But there's real value in whether it's me or someone else paying a professional to do so. You pay a professional to invest for you because they have the skill to do that, right? I don't do my own books. I have a bookkeeper and an accountant because that's not where my skill is, right? It's always a lot more expensive to not do things correctly than it is to do it correctly.
How often we should review the estate plan?
Well, I talk to my clients at least once a year. Just sometimes the conversations are short. Has anything changed? Have you acquired any new assets? Are we making sure we're protecting them? Have the people you named as your agents, are they still the right people? Have they moved maybe? Or, you know, you had your parents as the guardians of your children if something were to happen to you. Well, now maybe your parents are a little older and maybe they're not the right people or somebody's moved. Should we change those things? So we try to review those things. I tell people anytime you've acquired an asset, if you've relocated, anytime, have you had another child? Has there been a marriage in your family? Anytime there's a significant life event, you should at least have your documents reviewed, your plan reviewed. I have plenty of people, in Raleigh, we've got lots of people whose parents are moving here because their children are working here and, they're coming from the Northeast or whatever to move and be closer to their grandchildren. I have a lot of those people come in and say, can you look at my documents? And we start with, well, what are your goals? And when we know what their goals are and what they're trying to achieve, we can then look at their documents and say, yeah, these are still meeting your goals. You're great. You're set. Or maybe they're not set. We need to make some changes. But that's a life change, moving from one state to another, that you should at least have your documents reviewed if you have them. Moving from state to state does not nullify your documents. If especially your will and your trust, if they were legally executed in the state in which you did them, then just by moving doesn't nullify those. They don't have to be redone. They're still valid.
Okay. So anytime I'm doing a new transaction, like, buying a property, like a commercial property or something, do I need to notify someone if I already have a living trust?
Well, you don't have to, but you might want to have a conversation of, hey, I'm acquiring this property. do I want to put this in the trust? If I do want to put it in the trust, what's the correct way to do that to make sure it gets into that trust? If you're a sophisticated investor and you've done it before, you probably know how to do it. But I tell my clients it's at least worth picking up the phone and having a 5 or 10 minute conversation with me to make sure you're doing it correctly and you're doing and it's going to get the result you intend it to be.
Do you also work with the companies, corporate? They have benefits like estate planning.
I'm not part of any type of plan where companies, that have some type of legal group or legal insurance, something like that. I do not work with those.
Okay.
Okay, we have a question. Is that one-time fee for the will and closing attorney, or will there be cost for that lifetime? What's the cost for annual review? So is there a cost for annual review on this?
So in our practice, it's a one-time fee to prepare your documents, to prepare your plan. You can then choose to either be part of our maintenance program, which is an annual fee, or you can just choose to pay me my hourly fee whenever you feel that you need to. I think the advantage of being a part of the maintenance plan, it puts the onus on me to check up with you. The other thing I find that is people tend not to pick up the phone to call me when they know they're going to get a bill for it. But if they know like insurance, they've paid for it, they're more likely to call me. And I'd rather have my clients call me and have me tell them they're all set and they're okay, than to find out 5 or 10 years down the road that they didn't do it right and they created the mess that they were trying to avoid.
Yeah.
Just to tell you a bit about my process, our initial meeting is what we call a vision meeting. That's where we'll sit down and talk about what are your goals, what are you trying to achieve? Because everybody's goals are different. So we create plans for individuals. Not everybody should get the same thing. That initial meeting is free. And at the end of that initial meeting, we will give you some options on how we can meet your goals and what the prices are. And then the client can decide if and how they want to move forward. If they decide they want to move forward, the next meeting is what we call the design meeting. That's where we'll get the particulars, the who's, the what's, the when's, the how's. Then we prepare the documents for review by the client. They can change them at that time, make additions, subtractions, corrections, whatever they want to do. Then they come in and sign it. Our goal is to get it done within 20 days from the time the client says they want to move forward. What I would say to all the people on this call is if you do not have an estate plan, whether you use me or someone else, don't go through life without an estate plan. Don't leave a mess for your children. You could get hit by a cement truck tomorrow, and you could have all these goals of what you want to have happen, and they're not going to happen if you don't have a plan in place. So I would just encourage you to do something, whether it's with me or someone else, have some conversations. We all know we need to do it. Life gets busy, life gets in the way. I don't know anything about the people on this call, how old their kids are, but kids are busy. They have soccer practice. You have kids in college. You have parents you're taking care of. All those things can eat up a lot of your brain space and a lot of your time. And that's why people don't get these things done. Let me encourage you just to set aside the time to do it, to start having conversations, start moving forward if you haven't done something, again, by somebody, just so you get it done. That's important to me. My parents, I do what I do because my parents did an amazing job with their estate plan. They left a legacy. They left a legacy that continued the way they lived their lives. They treated myself and my 6 siblings in their estate plan the same way they treated us in life. And I'll tell a quick story. My wife always tells me I say too many stories. Growing up, we solved everything by drawing names out of my parents had this lamp that had this copper kettle on it. And everybody's name, every time we had to decide something, everybody's names got put in there and we pulled names out of there. And that's how we decided where we sat in the car or who sat where at the dinner table. So we didn't have arguments. That's just how we solved things. So I got 5 brothers, 1 sister, and we all knew my sister was going to get my mom's jewelry. It just made sense. So we're at my dad's funeral. My dad was the second one to pass. And my sister says, we're at my brother's house, one of my brother's house. And my sister says, Mom had these pearls, this pearl necklace that Dad bought when he was traveling in Asia. And I have pearls for my husband. So I want one of my sister-in-laws to have these pearls. And as soon as she said that, I've got 22 nephews and nieces. One of my nieces went, and for some reason, my brother has this stupid lamp with the kettle with the broken handle on it. My niece grabs that kettle and puts all my sister-in-law's names on pieces of paper and holds it above my sister's head. And my sister pulls one of my sister-in-law's names out and then hands her my mom's pearls. Nobody argued about it. Nobody fussed. Nobody said it wasn't fair. And it just made me think my parents were watching this saying, that's what we passed on to my children. Our children don't argue about things. They know how to solve conflict or make decisions. And that's part of the legacy. And legacy also, let me encourage you to write things down, write stories down. And this wasn't personal experience, but I read this. There's a story about a grandmother calls her 16-year-old granddaughter into her bedroom and gives her her engagement ring and tells her the story about how grandpa had to work really hard to save the money and how he asked her to marry her And then she says to her granddaughter, when your next cousin, female cousin, turns 16, your responsibility is to give her this ring and pass on the story that goes with this ring. What we're creating here is legacy. And legacy is not just money. It's relationships, it's family, it's how you pass things on. And that's all part of your estate plan. And I want to encourage you all to put that into your plans, your stories, because 2 generations from now, no one's going to care about the money. They're going to care about the relationships. So let me encourage you, end with encouraging that.
Wow. Yeah, this is really great. This is this is the education that we all needed. And yeah, it's a great service to the community. There is one more question. Can we include the international properties in our estate plan?
I don't have an answer for that because I don't know, because I've never done that before, to be honest with you.
Okay.
So if I had an individual who came to me with that issue, I'd look into it, but I have not had that come up yet.
Okay. Yeah, I think we are over the hour. So
One
Okay.
more quick question I would like to ask Lars. What happens to the intellectual property or any digital assets like records or crypto? I mean, what happens to that in trust?
Yeah, the law is ever expanding on that because it's so new.
Mhm.
But yeah, you pass those on the same way you would pass on tangible property.
Okay.
And things like power of attorneys and wills include those things now, to include intellectual property, digital assets, and down to like access to Facebook pages and Instagram and
Mhm.
Twitter, whatever it may be. It includes all those things now.
Okay.
wow.
That's great. I think then we are almost near the end. How can our listeners reach you?
You can go to my website, which is oakcityestateplanning.com. Got all my information there. And you just give us a call. Through the website, you can send me an email, you can call me, you can fill out a contact form. And we will always get back to you within 24 hours of when you call us. If I'm not in the office or if I'm in a meeting, you can leave a message with my assistant, Janie. And I will, if I don't get back to you that day, I will definitely get back to you within 24 hours.
Okay, that's great. OakCityEstatePlanning.com. Very good.
That's it.
Yeah. Yeah, well, thank you so much, Lars, and coming out, speaking here and giving us a lot of insight about estate planning. Thank you so much.
Thank you for having me. I appreciate it.
Yeah, thank you so much. Have a good night. Thanks,
too.
everyone.
Thank you, everyone. Bye-bye.